Basics: corporate governance, simplify regularity, interest applicability. Companies incorporated act or under previous company law, company, insurance company, third banking company, fourth company engaged in generation or company governed by any special act for the time being in force. Sixth point, any other body governance specified by the central government, not in case of insurance company, banking company, company engaged in the generation or supply of electricity, except where provision inconsistent with the Indian Regulatory Development Act 1999 or Banking Regulation Act 1949 or Electricity Act 2003. Meaning and features of company. Definition. Section number 220 of the Companies Act 2013 defines the term company. Company means a company incorporated under this act or any previous company law. Features of a company: separate legal entity and separate from that of its members. Company can own property, have bank account, raise loans, incur liabilities, and enter into contracts. It is at law a person which is different from the subscribers to the memorandum of association. Even members can contract. Even members can contract with company, acquire right against it, or incur liability to it. For the debts of the company, only its creditors can sue it and not its members. Shareholders are not owners of company's capital and assets, even though contributed by them. Member does not have an insurable interest in the property of the company. Case law: Macquarie versus Northern Assurance Company Limited, 1925. Second point, perpetual succession. Members may die or change, but the company goes on till it is wound up. Shares of the company may change hands infinitely. That does not affect the existence. Since a company is an artificial person created by law alone can bring its law alone can bring an end to its life. Its existence is not affected by the death or insolvency of its members. Limited liability. Limited liability company. The liability of the members limited to the extent of nominal value of shares held by them. Maximum liability up to the unpaid value of shares. Company limited by guarantee. Amount guaranteed by them, and that too only when the company goes into liquidation. Unlimited company. The liability of its members is unlimited as well. Fourth point, person. All points of separate legal entity plus it can do everything which any natural person can do except be sent to jail, take an oath, marry or practice a learned profession. Company is an artificial person. It can act only through some human agency with the directors. Directors act as its agency, but they are not the agents of the members of the company. For authentication, directors can either on their own or through the common seal. Perpetual succession, second point, green tick. Common seal, green tick. Company works through the agency of human beings. Common seal is the official signature which is affixed by the officers and employees of the company on its every document. Common seal is the symbol of its incorporation. The company's Amendment Act 2015 has made the common seal optional. The documents need to be authenticated by a common seal will be required to be so done only if the company opts to have a common seal. In case a company does not have a Common share authorization shall be to directors or by director and the company secretary, wherever the company has appointed company secretary. Members of a company are shielded from liability connected to the company's action. Company incurs any debt or contravenes any laws. The corporate will concept implies that members should not be liable for those errors. Thus, the shareholders are protected from the acts of the company. Shareholder can't be held liable for acts of company even though he holds the entire share capital. Case law, red tick. Salomon versus Salomon and Company Limited. लिफ्टिंग ऑफ कॉर्पोरेट विल, ये तो रेड टिक है, इसके ऊपर है, केस लो के ऊपर नहीं है. Where the court ignores the company and concern themselves directly with the members or managers, the corporate will may be said to have been lifted. Only in following circumstances the court are willing to lift the corporate will. Red tick. Determine the character of the company. Daimler Company Limited versus Continental Tire and Rubber Company. Test of control is adopted to determine company as a friend or foe. FOE. Red tick. To protect revenue slash tax. Dinsho Manekji Petit corporate entity is used to evade or circumvent tax. Court will disregard the corporate entity to avoid a legal obligation. Red tick. Associated Rubber Industries Bhavnagar versus the Associated Rubber Industries Limited Bhavnagar and another. New company is created to reduce the gross profit. Red tick. Formation of subsidiaries to act as agents. Merchandise Transfer Limited versus British Transport Commission 1992. Parent and subsidiary are treated as one commercial unit. Formed for fraud, improper conduct or to defeat law. Guilford Motor Company versus Horn. Device of incorporation is adopted for some illegal or improper purposes under the Act 16 types on the basis of liability. Company limited by shares. Section 2, subsection 22. When liability of the members of a company is limited by its memorandum of association to the amount, if any, unpaid on the shares held by them, it is known as a company limited by shares. That ownership of the not the owners of the company, even though contributed by them. Rights and duties of a shareholder as co-owner is measured by his shareholdings. That tick. Company limited by guarantee. Section 2, subsection 21. Liability of its members limited to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of winding up. Members can't be called upon to contribute beyond that from its members useful only where no working funds are needed or where these funds can be held from other sources like donation, etc. The common features between a guarantee company and the company having share capital are legal personality and limited liability. Both of them have to state in their memorandum that the member's liability is limited. Point of distinction is guaranteeing company. Members may be called upon to discharge their liability only after commencement of winding up, but company limited by shares may be called upon to do so at any time, either during the company's lifetime or during its winding up. Case law. In a Narendra Kumar Agarwal versus Saroj Malu. Unlimited Company, Section 2, Subsection 92, Green Tick. Company can be limited on the liability of its members. Liability of a member ceases when he ceases to be a member. Liability extends to whole amount of the company's debt and liabilities, claim, contribution, So long as the company is a going concern, the liability on the shares is the only liability. Creditors can institute proceedings for winding up of the company for their claims. The official liquidator may call the members for their contribution, which can be unlimited. On the basis of members, one person company, section 2 subsection 62 Reddit. Companies Act 2013 defines OPC as a person which has only one person as a member. OPC is a private limited company with the minimum paid up share capital prescribed and having one member. Member can be the sole me- Member can be the sole member and director of one person company. Minimum paid up capital no limit prescribed. Memorandum shall indicate the name of the other person who shall in the event of a subscriber's death or his incapacity to contract become the member of one person company. Other person shall give his prior written consent in prescribed form and the same shall be filed with the registrar at the time of incorporation of company. Right to withdraw may be given shall be nominee for the sole member of a one person company. Means a person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. No person shall be eligible to incorporate person company, more than one person company, or become nominee in more than one such company at a time. No minor shall become member or nominee of one person company or can hold share with beneficial interest. One person company can't be incorporated or converted. Section 8 company converted. Section 8 company can be converted to private or public company. One person company can't carry out non banking financial investment activities, including investments of any body corporates. Private company, section 2, subsection 68. Red tick. Private and which is by its articles restricts the right to transfer its share except in case of one person company, limits the number of its members to 200, prohibits any invitation to the public to subscribe for any securities of the company, provided where two or more persons hold one or more shares in the company jointly, they shall, for the purpose of this clause, be treated as single member. Following shall not be included in the number of members: persons who are in the employment of the company and persons who having been formerly in the employment of the company have continued to be members after the employment ceased. Number of members minimum 2, maximum 200. One person company 1. Small company and one person company can be formed as private company. Small company, section 2 subsection 85. Small company means a company other than a public company whose paid up share capital does not exceed 4 crore rupees or such high amount as may be prescribed, which shall not be more than 10 crore rupees, and turnover of which, as per profit and loss account for the immediately preceding financial year, does not exceed 40 crore rupees or such a high amount as may be prescribed, which shall not be more than 100 crore rupees. Exceptions: this clause shall not apply to a holding company or a subsidiary company. Section 8 company, a company or body corporate governed by any special act. Public company. Section 2 subsection 71. Public company means a company which is not a private company and has minimum paid up share capital prescribed, provided that a company which is a subsidiary of a company shall be deemed to be a public company even where such a subsidiary company continues to be private company in its articles. Shares are freely transferable. Number of members minimum 7, maximum no limit. On the basis of control. Holding and subsidiary companies, section 2 40 subsection 46 and section 2 subsection 87. respectively. Red tick. Holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. Company includes a body corporate, subsidiary company in relation to any other company, that is to say, the holding company means a company in which the holding company controls the composition of the board of directors or exercises or controls more than one half of the total voting power either at its own or together with one or more of its subsidiary companies. Controls the board of directors means that the other company by exercise of some power exercisable by it at its discretion can appoint or remove all a majority of the directors. A company shall be deemed to be a subsidiary company of the holding company, even if the control is of another subsidiary company of the holding company. Private company which is subsidiary of a public company shall be deemed to be a public company. Holding companies shall not have layers of subsidiaries beyond numbers as may be prescribed. Associate company red tick. Section 2 subsection. Section number 2 subsection 6 associate company red tick means a company which is associate company means a company which is in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Significant influence means control of at least 20% of the total voting power or control of all participation in business decisions under an agreement on the basis of access to capital. Listed company section number 2 subsection 52. Company which has on any of its securities listed on any recognized stock exchange. Unlisted company, company other than listed company, other companies, government company, section 2 subsection 45. Green tick. Any company which in which not less than 51% of the paid up share capital is held by the central government or by any state government or governments or partly by central and partly by one or more state governments and includes the subsidiary of such a government company. Paid up share capital shall be constituted as total voting power where shares with differential voting rights have been issued. Foreign company, section 2, subsection 42. It means any company or body corporate incorporated outside India which has a place of business in India whether by itself or through an agent physically or through electronic mode and conducts any business activity in India in any other manner. Section 8 company charitable objects promotes the charitable objects and intends to apply its profits in promoting its objects and prohibiting the payment of any dividend to its members can call its general meeting in 14 days instead of 21 days. A partnership firm can also be a member in Section 8 company license. Section 8 allows the central government to register a person or association of persons as a company with limited liability without the addition of words limited or private limited to its name. Registrar on application will register the company and it will enjoy privileges of a limited company. Revocation of license. Green tick. The central government may by order revoke the license of the company where the company contravenes any of the requirements or conditions subject to which a license issued or where the affairs of the company are conducted fraudulently or violative of the objects of the company or prejudicial to public interest. On revocation, registrar shall put a limited or private limited to its name before revocation. Central government must give a written notice of its intention and opportunity of being heard. Order of central government where a license is revoked. Central government may in the public interest order to amalgamate with another company registered under this section having similar objects to form a single company with such conditions as the central government deem fit all wound up. Penalty slash punishment in contravention of any of the requirements of this act. Company not less than 10 lakh rupees, 10 lakh company not less than 10 lakh but may extend to 1 crore, and director and every officer in default fine not less than 25,000 but may extend to 25 lakhs if a fraud liable under section 447. Dormant company section number 455 red tick, where a company is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction. Such a company or an inactive company may make an application to registrar to get the status. Inactive company means a company which has not been carrying on any business or operation or has not made any significant accounting transaction during the last 2 financial years, or has not filed financial statements and annual returns during the last 2 financial years. Significant accounting transaction means any transaction other than payment of fees by a company to the registrar, payment made by it to fulfill the requirements of this act or any other law, allotment of shares to fulfill the requirements of this act, and payments for maintenance of its office and records. Nidhi companies, section number 406, subsection 1. Nidhi companies are created for cultivating the habit of thrift and savings amongst its members. Public financial institutions, section number 2, subsection 72, green tick. Following institutions are to be regarded as public financial institutions: Life Incorporation of India, established under the Life Insurance Corporation Act 1956; Infrastructure Development Finance Company Limited, specified company referred to in the Unit Trust of India. Institutions notified by the central government under Companies Act 1956, so repealed. Institutions are notified by the central government in consultation with the RBI. No institution shall be notified unless it has been established or constituted by or any other central or state act. Not less than 51% of the paid up share capital is held or controlled by central or by any state government, or governments or partly by central and partly by one or more state governments. Mode of registration slash incorporation of a company. Promoters. Section number 2, subsection 69. Red tick means a person who has been named as such in a prospectus or is identified by the company in the annual return referred to in section 92, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, in accordance with those advice, directions, or instructions the board of directors is accustomed to act. ACCUSTOMED, accustomed to act. Persons who form the company are known as promoters. It is they who conceive the idea of forming the company. They take all necessary steps for its registration. However, persons acting in the professional capacity are not regarded as promoters. Formation of company, section number 3. Public company, 7 or more persons. Private company, 2 or more persons. One person company, one person can form a company for any lawful purpose by subscribing their names to memorandum of association. Incorporation of a company, section number 7. Red tick. Procedure to be followed for incorporation of a company. File the following documents to the registrar of the registered office jurisdiction: the memorandum and articles of the company duly signed by all the subscribers, declaration by person who is engaged in the formation of the company and by a person named in the articles that all the requirements of these acts and the rules made there under in respect of registration have been compiled with declaration of a declaration from each of the subscribers to the memorandum and first directors that he is not convicted of any offense in connection with promotion, formation, or management of any company, or he has not been found he has not been found guilty of any fraud or misfeasance or breach of duty to any company during the last 5 years. That all the documents filed with the registrar contain information that is correct and complete and true to the best of his knowledge, and if the address for correspondence till its registered office is established, the particulars of every subscriber to the memorandum along with the proof of identity, the particulars of the interest of the first directors of the company in other firms or bodies corporate along with their consent to act as directors of the company. Particulars provided in these provisions shall be of the individual subscriber and not of professional engaged in the incorporation. Issue of certificate of incorporation on registration. Registrar shall register all the documents and information in the register and issue a certificate of incorporation. Allotment of corporate identity number. Registrar shall allot to the company a corporate identity number which shall be distinct identity for the company on and from date mentioned in corporate in COI. COI. Certificate of incorporation. Date mentioned in certificate of incorporation. Maintenance of copies of all documents and information. Company shall maintain and preserve at its registered office copies of all documents and information as originally filed till its dissolution. Furnishing of false or incorrect information or representation or suppression of material fact at the time of incorporation. If any person furnishes any false or incorrect particulars or suppresses any material information which he is aware or in any documents in any of documents filed with the registrar in relation to the registration, he shall be liable for action of fraud under section 447. Company already incorporated by above post incorporation, where at any time after the incorporation of the above is proved, then the promoters, the first directors, and the persons making declaration under this section shall be liable for fraud under section 447. Order of the tribunal. Company has been incorporated by above FIRS. FIRS. Then the tribunal may, on an application made to it, being being satisfied that the regulations so warrants, pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles in public interest or in the interest of the company and its members and creditors, or direct that liability of the members shall be unlimited, or direct removal of the name of the company from the register of companies, or pass an order for the winding up of the company, or pass such orders as it may deem fit, provided that before making an order, company shall be given reasonable opportunity of being heard, and the tribunal shall take into consideration the transaction entered into by the company. Simplified pro forma for incorporating company electronically. SPICE. Ministry of Corporate Affairs has taken various initiatives for ease of business. It has simplified the process of filing of forms for incorporation of a company through SPICE. Effect of registration of a company, section number 9. From the date of incorporation mentioned in the certificate of incorporation, it shall be a body corporate by the name contained in the memorandum. All points of separate legal entity there comes into a binding contract between the company and its members as evidenced by memorandum and articles of association. Company may purchase all shares of another company, but it will not end its corporate character of another company, and each company is a separate juristic, juristic entity. Mere fact that the entire share capital has been contributed by the central government and all its shares are held by the President of India does not make any difference in the position of company, and it does not make a company an agent either of the President or the central government. Effect of memorandum and articles when registered. Section number 10, green tick. Memorandum and articles when registered shall bind the company and members as if they respectively had been signed an agreement to observe all the provisions of memorandum of association and article of association. All monies payable by any member to company under M/A under memorandum or articles shall be a debt due from him to company. Classification of capital debt. Capital means the share capital divided into shares of fixed amount. Contributions of person to the common stock of company form the capital. Proportion of the capital to which each member is entitled is his share. A share is not a sum of money, it is rather an interest made up of various rights. Nominal or authorized or registered capital. Section 2, subsection 8. As is authorized by memorandum needed to raise upon which stamp duty is paid. Usually fixed estimated amount, company will need to disclose its issued capital in the balance sheet. Subscribe capital. Section number 2, subsection 86. Other official communication issued shall state the pub- authorized, subscribed, and paid up capital in conspicuous characters. Default company and every official penalty 10,000 and 5,000 respectively. Section number 60. Called up capital. Section number 2, subsection 15. Such part of capital which has been called for payment on shares issued. Paid up capital. Total amount paid or credited as paid up on shares issued. Called up less colon earlier. Shares. Section number 2, subsection 84. Share means the share in the share capital of a company and includes the stock. It represents the proportion of the interest of the shareholders measured by a sum of money, shares slash debentures slash other interest of a company are a movable property manner of association not applicable for holder of a beneficial interest in the records of a depository. Kinds of share capital. Section number 43. Equity share capital means all share capital which is not preference share capital. Equity share capital with the voting rights. Equity share capital with rights to dividend votings or otherwise. Preference share capital means that part of the issued share capital of the company which carries or would carry a preferential right with respect to payment of dividend either as a fixed amount or amount calculated as at a fixed rate which may either be free or may either be free of or subject to income tax and repayment in the case of a winding up or repayment of capital of the amount of the share capital paid up or deemed to have been paid up. Exception in case of private company, section number 43 shall not apply where MOA and AOA provides memorandum of association. It is in fact its charter. It defines its constitution and the scope of the powers of the company. It is very foundation on which the whole edifice structure of the company is built. Object of registering a memorandum of association. Red tick contains objective for which the company is formed, identifies possible scope of its operations beyond it cannot go. If it does so, it will be ultravires the company and void. Enables creditors, enables shareholders, creditors, and all those who deal with the company to know what its powers are and what activities it can engage in. Memorandum is a public document, section number 399. Consequently, every person entering into a contract with the company is presumed to have the knowledge of of conditions contained therein. Shareholders must know purposes for which his money can be used and what risk he is taking in the taking in making the investment. As per section number 4, memorandum of a company shall be drawn up in such form as given in tables. Table A, memorandum of association of a company limited by shares. Table B, company limited by guarantee and not having a share capital. Table C, company limited by a guarantee and having a share capital. Table D, unlimited company not having share capital. Table E, unlimited company and having share capital. Note: the memorandum of association and article of association of a company must be as close to model forms as possible. Memorandum must be printed and divided into paragraphs, number consequently, and signed by at least 7 members, two in case of a private company and one in case of one person company, in the presence of at least one witness who will attest to the signatures. Company being a legal person can through its agents subscribe to its memorandum. Minor can't be a signatory as he is not competent to contract. Guardian of a minor who subscribes will be deemed to have subscribed in his personal capacity. Memorandum of association can't contain anything contrary to the provisions of the Companies Act, no legal effect. All other documents of a company must comply with the provisions of the memorandum. Content of the memorandum: the memorandum of a company shall state, red tick, name clause, name of a company with the last word limited in case of public limited company, or the last words private limited in case of private limited company. In case of one person company, the words one person company should be included below its name. Government company's name must end with the word limited. This clause is not applicable on Section 8 companies. Section 8 companies shall include the words as given under the Companies Incorporation Rules 2014. Registered Office Clause: the state in which the registered office of a company is to be situated. Object Clause: objects for which the company is proposed to be incorporated and any matter considered necessary is furtherance thereof. Note: if the company has changed its activities which are not reflected in its name, it shall change name in line with the activities within a period of 6 months from a change of activities. Liability clause: liability of members, whether limited or unlimited, and also state in the case of a company limited by shares, liability is limited to the amount unpaid, and in the case of company limited by guarantee, amount up to which each member undertakes to contribute to the assets of the company in the event of its wound up while he is a member at the time of winding up, or within 1 year after he ceases to be a member before winding up, for payment of debts and liabilities. contracted before he ceases to be a member to the costs, charges, and expenses of winding up and for adjustment contributories. Capital clause. Amount of authorized capital divided into share of fixed amounts and the number of shares with the subscribers indicated indicated opposite their names, which shall not be less than one share. This clause will not apply to company not having share capital. Association clause. Details of subscribers to form company MOA shall conclude with this clause. Every subscriber to MOA shall take at least one share and shall write against his name the number of shares taken by him. Succession clause. In the case of one person company, the name of the person who, in the event of death of the subscriber, shall become the member of the company. Articles of association. Articles of a company are its rules, regulation framed to manage its internal affairs. Articles play a part subsidiary to memorandum of association. It provides the mode and form in which the business slash changes of a company is to be carried on. The document containing the articles of association of a company, the Magna Carta, is a business document. Hence, it has to be construed strictly. It regulates the domestic management of a company and creates certain rights and obligations between the members and the company. Articles are the bylaws of a company according to which director and other officers are required to perform their functions as regards to management office accounts and audit of company. Section 5 of the Companies Act 2013 seeks to provide the contents and model of articles contains regulation. Articles shall contain the regulation for management of a company, inclusion of matters. Also contain such matters as are prescribed under the rules, also include additional matters as may be considered necessary for its management. Contains contain provisions for entrenchment. Green tick. Articles may contain provisions for entrenchment to the fact that specified provisions of the articles may be altered only if conditions or procedures which are more restrictive than the special resolution are met or compiled with. Manner of inclusion of the entrenchment provision made either on formation of a company or by an amendment in the articles agreed to by all the members in case of a private company and agreed by special resolution in case of public company. Notice to the registrar for the entrenchment provision, whether made on formation or by amendment, the company shall give notice to the registrar in the manner prescribed. Forms of articles. Articles shall be specified in tables F, G, H, I, and J in Schedule 1. Model articles. A company may adopt all or any of the regulation contained in the model articles applicable to such company if it does not do not exclude or modify the model applicable. It shall be applicable in same manner as if they were contained in the registered article. Difference between MOA and AOA. Green tick. Objectives, relationship, alteration, ultravirus. Doctrine of ultravirus. Mm. Meaning of the term ultravirus is simply beyond their powers. Fundamental rule of company law that the objects of can be departed from only to the extent permitted by act. The impact of ultravirus is that a company can neither be sued nor can it sue on it. Memorandum is a public document. It is open to public inspection. Therefore, when one deals with a company is deemed to know about the powers of a company. If enter into a transaction which is ultravirus, the company you can't enforce it against it. An act which is ultravirus, the company being void, can't be ratified by the shareholders of the company. Ultravirus contract can never be made binding on the company. It can't become intravious case law. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. When an act is performed through which legal in itself is not authorized by objective clause of the memorandum, it is said to be ultravious the company and hence null and void. An act which is ultravious the company can't be ratified even by the unanimous consent. An act which is ultravious the directors but intravious the company can be ratified by the members of the company through a resolution passed at a general meeting. If an act is ultravious the articles, it can be ratified by altering it can be ratified by altering the articles by a special resolution at a general meeting. Doctrine of indoor management. Doctrine of constructive notice. Green tick. Any person can inspect, make, record, get a copy or extracts of any document kept with the registrar on payment of prescribed fee. Section number 399. Memorandum of Association and Article of Association when registered becomes public documents and hence available for inspection. It is therefore the duty of every person dealing with the company to inspect its documents and make sure that his conduct is in conformity with the provisions, but whether a person reads them or not, it will be presumed that he have the knowledge of the contents and also understood them in true perspective. All the documents, this kind of presumed or presumed slash implied notice is called a constructive notice. Thus, if a person enters into a contract which is beyond the powers of the company or outside the authority of directors, he can't acquire any rights under the contract against the company. Doctrine of indoor management slash Turkman rule. It is the exception to the doctrine of constructive notice. It does in no sense mean that outsiders are deemed to have notice of the internal affairs of the company. If an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. Case law Royal British Bank versus Turquand. Exceptions to the doctrine of indoor management. Actual or constructive notice of irregularity. Rule does not protect any person when the actual person dealing with the company has notice, whether actual or constructive, of irregularity. Case law Howard versus Patent Ivory Manufacturing Company. Suspicion of irregularity. The doctrine in no way rewards those who behave negligently. Where the person dealing with the company is put upon an inquiry, it is duty of the outsider to make the necessary inquiry. Case law Anand Bihari Lal versus Dinshaw and Company. Forgery. The doctrine of indoor management applies only to irregularities which might otherwise affect a transaction, but it can't apply to forgery as it is nullity. 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 Case law Ruben versus Great Fingal Consolidated and Companies Act 2013 over. चलो फ्रेंड्स जल्दी से इसको ख़त्म करते हैं। नेगोशिएबल इंस्ट्रूमेंट्स एक्ट 1881। मीनिंग ऑफ नेगोशिएबल इंस्ट्रूमेंट्स। Negotiable instruments is an instrument documents which is freely transferable from one person to another by mere delivery or by endorsement and delivery. The property in such an instrument passed to a bona fide transferee for value applicable to whole of India. Kinds of negotiable instruments. The Act does not define the term negotiable instrument. However, section number 13 of the Act provides for only three kinds of negotiable instruments, namely bills of exchange, promissory note, and checks payable either to order or bearer. Characteristics of negotiable instruments: writing, signed, freely transferable. Fourth point: holder's title is free from debts, transferred any number of times till its satisfaction. Promise or order to pay money only. Sum payable, time of payment and pay must be certain, must be delivered, drawing not sufficient. Green tick, promissory note, section number 4. A promissory note is an instrument in writing, not being a banknote or a currency note containing an unconditional undertaking signed by the maker to pay a certain sum of money only to the order to the order of a certain person or to the bearer of the instrument. In case of promissory note, customer is the drawer, that is maker slash debtor slash payer, and the supplier is the drawee, that is bearer slash creditor slash payee. Specimen of a promissory note, green tick. Rupees 10,000 on the left side, राइट साइड में लखनऊ अप्रैल 10 2022 और एक पूरी लाइन में लिखा हुआ है 3 months आफ्टर दैट आई प्रॉमिस टू पे श्री रमेश ब्रैकेट में पे और टू हिज ऑर्डर द सम ऑफ रुपीज 10,000 फॉर वैल्यू रिसीव्ड राइट साइड को स्टैम्प सिग्नेचर शायद लिखा हुआ है SD स्लैश और इक्वल एक लाइन मरी हुई है राम और लेफ्ट साइड को लिखा हुआ है टू श्री रमेश B20 ग्रीन पार्क मुंबई मेकर parties to promissory note maker. The person who makes the promise to pay is the maker. He is the debtor and must sign the instrument pay. Pay is the person to whom the amount on the note is payable. Essential characteristics of a promissory note. Promise to pay is not sufficient. There must be an express promise to pay. Mere acknowledgement of debt is insufficient. The promise to pay must be definite and unconditional, dependent on happening or non-happening of an event are not promissory notes. However, promise to pay may be subject to condition which according to ordinary experience of mankind is bound to happen. Must be signed by the maker. Must be signed by the maker, otherwise it is incomplete and ineffective. Pay money only, pay a certain sum, but if the amount payable can be easily ascertained, promissory note is valid. Maker and pay must be certain, definite, and different persons. A promissory note cannot be made payable to the bearer. Section number 31 of the RBI Act 1934. Only RBI, all the central government can make or issue a promissory note payable to bearer must be properly stamped and cancelled in accordance with the Indian Stamp Act. Bills of Exchange, Section number 5. Green tick. A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Specimen of a bill of exchange, green tick. राइट साइड को लिखा मिस्टर ए ड्रोवर 48 MP नगर भोपाल MP अप्रैल 10 2022 राइट साइड को रुपीज़ 10,000 और बीच में एक ऐसा लिखा हुआ है, मतलब ये 4 months after date pay to Mr. B ब्रैकेट में पेई a sum of rupees 10,000 for value received, ये लेफ्ट साइड में लिखा है टू मिस्टर सी ब्रैकेट में ड्रॉई 576 एरिया कॉलोनी भोपाल MP, राइट साइड को सिग्नेचर मिस्टर ए, पार्टीज टू बिल ऑफ एक्सचेंज, ड्रॉअर द मेकर ऑफ अ बिल ऑफ एक्सचेंज, द ड्रॉई person directed by drawer to pay is called drawee, on whom bill is drawn on acceptance called an acceptor and is liable for payment primarily and unconditional. Payee person named to whom or to whose order money is directed to be paid. Essential characteristics of a bill of exchange: first, writing express order to pay; second, defined and unconditional; third, must sign the instrument; certain sum money only must be stamped; eighth point, drawer, drawee, and payee must be certain, may not necessarily be three different persons. One can play the role of two. Green tick. As per, as per Section 31 of the RBI Act 1934, bill of exchange can't be made payable to bearer on demand. However, bill of exchange payable on demand in which name of the payee is mentioned is valid. Difference between promissory note and bills of exchange. Definition, nature, parties, acceptance, or fifth point, payable to bearer. Check, red tick. Section number 6. A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and check in the electronic form. Payable on demand means payable whenever holder chooses to present it to drawing bracket में banker. Check in the electronic form means a check, इसके ऊपर ग्रीन टिक है, चेक इन द इलेक्ट्रॉनिक फॉर्म मीन्स चेक ड्रॉन electronic form by using any computer resource and signed in a secure system with a digital signature with slash without biometric signature and asymmetric crypto system or electronic signature as the case may be. Red tick. A truncated check means a check which is truncated during a clearing cycle either by the clearing house bracket में managed by clearing house or by the bank, whether paying or receiving payment immediately on generation of an electronic image for transmission, substituting the further physical movement of the check in writing. Check is also a bill of exchange but is drawn on a banker and payable on demand. Specimen of check: gross, parties to check, the person who drawer, parties to check drawer, the person who draws a check, that is makes the check bracket में debtor, his liability is primary and conditional. Drawee, the specific bank on whom check is drawn, he makes a payment. In case of check, drawee is always a banker. Green tick. Drawee in case of need, when in the bill in any endorsement thereon, the name of any person is given in addition to the drawee to be resorted to in case of need. Such person is called a drawee in case of need. Payee, the person named in the instrument, that is the person in whose favor check is issued, to whom or to whose order the money is by the instrument directed to be paid, is called the payee. The payee may be the drawer himself or a third party. Essential characteristics of a check. Note: the two additional features distinguish a check from bill. Thus, all checks are bill, while all bills are not checks. All the essential characteristics of a bill of exchange must be drawn on a specified banker. It must be payable on demand. Note: these two additional features distinguish a check from bill. Thus, all checks are bills, while all bills are not checks. Classification of negotiable instruments. BRL instrument and order instrument. Section number 13. BRL instrument erratic. It is an instrument where the name of the pay is blank and where the name of pay is specified with the words or BRL, or where the last endorsement is blank. Such instrument can be negotiated by mere delivery. Radiatic order instrument. It is an instrument which is payable to a person or payable to a person or his order or payable to order of a person or where the last endorsement is in full bracket में payable to a specified person and does not contain words prohibiting its transfer bracket close. Such an instrument can be negotiated by endorsement and delivery. Radiatic inland instrument. Section number 11. Place where an instrument is drawn and made payable. Promissory note, bill of exchange check made drawn in India. Residence of person on whom instrument is drawn. Payable in India or drawn upon a person resident in India. Nature of instrument are inland instruments. यहाँ पे तीन हेडिंग है ऊपर प्लेस वेयर इंस्ट्रूमेंट इज ड्रॉन एंड मेड पेबल इसके अंदर है प्रोमिसरी नोट बिल ऑफ एक्सचेंज चेक और लिखा हुआ है ड्रॉन स्लैश मेड इन इंडिया और रेजिडेंस ऑफ पर्सन ऑन होम इंस्ट्रूमेंट इन इज ड्रॉन ये सेकेंड हेडिंग है इसके अंदर लिखा हुआ है प्लस पेबल इन इंडिया और ड्रॉन प्लस में लिखा है और केवल प्लस में ड्रॉन अपॉन अ पर्सन रेजिडेंट इन इंडिया फिर आगे थर्ड मतलब लिखा है उसमें नेचर ऑफ इंस्ट्रूमेंट और उसमें लिखा हुआ है आल इनलैंड इंस्ट्रूमेंट मतलब इसका प्रोमिसरी नोट बिल ऑफ एक्सचेंज और चेक ड्रॉन या फिर मेड इन इंडिया और पेबल इन इंडिया और ड्रॉन अपॉन अ पर्सन रेजिडेंट इन इंडिया वो होते हैं आल इनलैंड इंस्ट्रूमेंट्स एन इनलैंड इंस्ट्रूमेंट्स रिमेन्स इनलैंड even if it has been endorsed and in a foreign country. Foreign instrument section number 12. Place where bill is drawn. ये मतलब फर्स्ट हेडिंग है जैसे उसके अंदर अब लिखा है प्रोमिसरी नोट बिल ऑफ एक्सचेंज चेक ड्रॉन स्लैश में मेड आउटसाइड इंडिया सेकंड हेडिंग जैसे जो रेजिडेंस ऑफ पर्सन ऑन होम ड्रॉन एंड प्लेस वेयर मेड पेपर इसके अंदर तीन हेडिंग है जैसे ऑन अ पर्सन रेजिडेंट इन और आउटसाइड इंडिया प्लस मेड पेपर इन इंडिया ऑन अ पर्सन सेकंड पॉइंट है ऑन अ पर्सन रिसाइडिंग आउटसाइड इंडिया प्लस पेपर आउटसाइड इंडिया ऑन अ पर्सन रिसाइडिंग इन इंडिया प्लस पेबल आउटसाइड इंडिया फिर आगे थर्ड में जैसे लिखा है थर्टी फाइव पॉइंट जो पड़ा ऑन अ पर्सन वाला फिर आगे नेचर ऑफ इंस्ट्रूमेंट आल फॉरेन बिल्स एक और बोलते हैं हम प्रोमिसरी नोट अभी तीन हो गए मतलब बीच वाला पढ़ेंगे हम ये पहले चलो ऊपर वाला पढ़ते हैं प्लेस वेयर बिल इज ड्रॉन इसके अंदर प्रोमिसरी नोट बिल ऑफ एक्सचेंज चेक ड्रॉन या फिर चेक ड्रॉन स्लैश मेड आउटसाइड इंडिया और इसके अंदर सेकंड जैसे वो लिखा हो उसके अंदर उसके नीचे तीन पॉइंट्स है ना रेजिडेंस ऑफ पर्सन ऑन होम ड्रॉन एंड प्लेस वेयर मेड पेबल ऑन अ पर्सन रेजिडेंट इन और आउटसाइड इंडिया प्लस मेड पेबल इन इंडिया पहला पॉइंट है सेकंड पॉइंट ऑन अ पर्सन रिसाइडिंग आउटसाइड इन इंडिया आउटसाइड फॉरेन बिल्स the liability of the maker or drawer of a foreign promissory note or bill of exchange or check is regulated in all essential matters by the law of the place where he made the instrument and the respective liabilities of the acceptor and endorser by the law of the place where the instrument is made payable unless contract to the contrary section number 134 inchoate instrument red case पे means an instrument that is incomplete in certain respects drawer slash maker slash acceptor slash endorsers of negotiable instrument may sign and deliver it to another person in his capacity, leaving instrument either wholly blank or having written on it the word incomplete. This gives the power to its holder to make it complete by writing any amount either within limits specified therein or within the limits specified by the stamps affixed on it. Principle of inchoate instrument is based on the principle of estoppel. The person signing and delivering the inchoate instrument is liable both to a holder and a holder in due course. Holder of such an instrument can't recover the amount in excess of the amount intended to be paid by the signer. Holder in due course can, however, recover any amount on such instrument provided it is covered by the stamp affixed on the instrument. On the In the absence of delivery, the signer is not liable. Also, instrument must be stamped. Ambiguous instrument section number 17 Letic, where an instrument may be construed either as promissory note or bill of exchange. Holder may at its discretion treat it as either, thus an instrument which is vague and can't be clearly identified either as a bill of exchange or as a promissory note is ambiguous instrument. However, after exercising his option, holder can't change that it is another kind of instrument. Negotiation bracket में transfer of negotiable instruments section number 14. Negotiable instrument and its sides are freely transferable from one person to another by negotiation. There is a transfer of instrument of the ownership of the instrument. Modes of negotiation में दो हैं. In case where promissory note, bill of exchange और check payable to bearer, इसमें आगे लिखा है बाई डिलीवरी, हो सकती है एक्चुअल या फिर कंस्ट्रक्टिव. और इसमें जैसे सेकंड पॉइंट लिखा है मोड ऑफ रजिस्ट्रेशन में इन केस वेयर प्रोमिसरी नोट, बिल ऑफ एक्सचेंज और चेक पेबल टू ऑर्डर है, उसमें एंडोर्समेंट प्लस डिलीवरी लिखा हुआ है. नेगोशिएशन बाय डिलीवरी सेक्शन नंबर 47. अ प्रोमिसरी नोट, बिल ऑफ एक्सचेंज और चेक डिलीवर अ प्रोमिसरी नोट, bill of exchange or check payable to bearer is negotiable by delivery thereof, subject to instrument obtained by unlawful means or for unlawful consideration exception. A promissory note, bill of exchange or check delivered on condition that it is not to take effect except in a certain event is not negotiable unless such event happens except in the hands of a holder for value without notice of the condition bracket close, except in the case except से start है bracket in the hands of a holder for a value without notice of the condition, yeah bracket close. Negotiation by an endorsement section number 48. Negotiation by endorsements. Bill of exchange or check payable to order is negotiable by the holder by endorsement and delivery thereof, subject to instrument obtained by unlawful means or for unlawful consideration. Green tick start. Importance of delivery negotiation section number 46. Delivery is essential whether payable to bearer or order. For affecting the negotiation, it must be voluntary and thus objective should be to pass the property in the instrument. The delivery must be actual or constructive. Actual delivery takes place when the instrument changes hand physically. Constructive takes place when it is delivered to the agent, clerk, or servant of the endorsee on his behalf, or when endorser, after endorsement, holds the instruments as an agent of the endorsee. When instrument is conditionally or for the special purpose only, the property in it does not pass to the transferee, even though endorsed, unless the instrument is negotiated to a holder in due course. Contract on a negotiable instruments remains incomplete and revocable until delivery. Delivery is essential not only at but also at the time of making slash drawing of negotiable instruments. Rights in instruments are not transferred to endorsee unless after endorsement delivered. If a person makes the endorsement but after delivery to endorsee, endorser dies, the legal representative of the deceased person can't negotiate the same by mere delivery thereof. Section number 57. Legal representative is not an agent of deceased, therefore can't complete the instrument if it was executed by the deceased but could not be delivered because of his death. Dishonor of check for insufficiency of funds, section number 138. Where any check drawn by a person on an account maintained by him with the banker mm, for payment of any amount due. For payment of any amount of money to another person from that account for the discharged in whole or in part of any debt of or other liability legally enforceable is returned by the bank unpaid either because of the mm, amount standing to the credit of that account is insufficient to honor the check or it exceeds the amount arranged to be paid from that account by an agreement made with the bank. Such person shall be deemed to have committed an offence criminal in nature and shall be punished with the imprison, imprisonment for a term which may extend to 2 years or with the fine which may extend to twice the amount of the check or with both. A check given as gift, donation, security slash gift slash donation slash security slash discharge of a mere moral obligation slash for an illegal consideration would be outside the purview of this section, provided that section shall not apply unless check presented within the validity period, that is within a period of 3 months from the date on which it is drawn or within the period of its validity, whichever is earlier, demand for payment through the notice in writing to drawer of check within 30 days of the receipt of the information from bank regarding the return of honor, return of check as unpaid, the and failure of drawer to make payment to the payee or to holder in due course within 15 days of the receipt of the said notice. Therefore, we may conclude that complaint can be filed after 45 days of dishonor of the check, that is 30 days of notice period plus 15 days of receipt of the said notice. Green tick. Section number 138 applies when a check is dishonored on account of stop payment instruction sent by drawer to banker in respect of post dated check irrespective of insufficiency of funds. Penalty. Dishonor of check is a criminal offense and is punishable with the imprisonment up to 2 years or fine up to twice the amount of check or both. Presumption in favor of holder. Section number 139. When a check is dishonored, it shall be presumed that the holder received the check for the discharge in whole or in part of any debt or in or any debt or other liability unless the contrary is proved. Defense not allowed in any prosecution under section number 138 bracket में लिखा section number 140 that the drawer had no reason to believe that he when he issued the check that the check may be dishonored on presentment for the reasons stated in that action. Presentment of instruments. Red tick. Presentment for acceptance. Section number 61. Bills of exchange. First one. Bill of exchange after sight bracket में no time slash place specified. सामने लिखा है इसकी reasonable time in business hour and day. Second point, in default, no party is liable. इसके आगे लिखा है ये. If drawee can't be found after reasonable search, ये सामने लिखा है bill dishonored. Bill is dishonored. ये false point लिखा है directed at particular place. उसके सामने लिखा है present at that place not found dishonor. Agreement or usage. Fifth point, through post office registered letter. Presentment of promissory note for site. Section number 62. Present उसके सामने लिखा है reasonable time in business hour and day. Draw is the time for deliberation. Section number 63. Red tick. Holder must allow the drawee for acceptance 48 hours exclusive of public holidays to consider whether he will accept it. Presentment for payment. Section number 64. Red tick. All points the same as for acceptance of section number 61. इसके सामने लिखा है exception where a promise is not payable on demand and not at a specified place. No presentment is necessary in order to charge the maker. Hours for presentment section number 65. उसके सामने लिखा है usual hours bracket में banking hours in case of banks. Payable after date or site section number 66. उसके सामने लिखा है must be presented for payment at maturity. payable payable by installments section number 67. उसके सामने लिखे हैं on the third day after date fixed for such installments. Installment payable at specified place section number 68. उसके सामने लिखे हैं at that place. No exclusive place specified section number 70. उसके सामने लिखा है at the place of business or at the usual residence of maker slash drawee slash acceptor. When maker etc. has no known place of business or residence. Section number 71. उसके सामने लिखा है wherever he can be found. Check to charge drawer. Section number 72. उसके सामने लिखा है at the bank upon which it is drawn. Check to charge any other person. Section number 73. Presented within a reasonable time after delivery thereof by such person. ये उसके सामने लिखा था पेबल ऑन डिमांड सेक्शन नंबर 74. उसके सामने लिखा है विद इन रीजनेबल टाइम आफ्टर रिसीविंग बाय और टू एजेंट स्लैश लीगल रिप्रेजेंटेटिव स्लैश असाइनी सेक्शन नंबर 75. उसके सामने लिखा है मे बी मेड टू एजेंट स्लैश लीगल रिप्रेजेंटेटिव स्लैश असाइनी excuse for delay in presentment for acceptance or payment. Section number 75A. उसके सामने लिखा है if forced by circumstances beyond control of holder when cause of delay ceases present within reasonable time. When presentment unnecessary. Section number 76. Instrument dishonored at due date. Red tick. If the maker slash drawee slash acceptor intentionally prevents the presentment or payable at place of business closes such place on business day in business hours or payable at some other specified place, neither he nor any person authorized to pay attends at such place during the usual hours of business or not being payable at any specified place, he can't after due research be found against the party sought to be charged if he has engaged to pay without presentment. If after maturity party with knowledge that the instrument was not presented makes a part payment or promises to pay the amount due thereon in whole or in part or otherwise waives his right to take advantage of any default in presentment against a drawer if the drawer could not suffer damage due to non-presentment. Liability of a banker for negligently dealing with the bill presented for payment. Section number 77. If the banker so negligently or improperly keeps deals with or delivers back such bill as to cause loss to the holder, he must compensate the holder for such loss. Rules of compensation. Section number 117. Red tick. Rules in case of dishonor of promising not bill of exchange or check. Holder is entitled to amount due with expenses incurred in presenting, noting, and protesting it when person charged resides at place different from that at which instrument was payable. Holder is entitled to receive sum at current rate of exchange between the two places. Endorses liable if a paid amount due entitled to amount so paid with interest at 10%, 18% per annum from date of payment until tender thereof with expenses caused by dishonor and payment when person charged and such endorser reside at different places. Endorser is entitled to receive such a sum at current rate of exchange between the two places. Party entitled to compensation can draw a Bill on the party liable to compensate him payable at site slash demand for amount due with all expenses incurred accompanied by instrument dishonored and the protest if any. If such bill is dishonored, make compensation in same manner as in case of original bill. And the chapters is over. Thank you friends.